You know, if you live in an HOA, this is probably a question you've wondered about. Can your board just change the rules on you without getting your vote? Well, that exact question went all the way to a judge, and believe me, the answer reveals a really crucial detail about where their power stops and yours begins.
So today we're breaking down this fascinating legal battle out of Scottsdale, Arizona. It's all about a fight over what you can and can't put on your own patio. And this is way more than just a little neighborhood squabble. This case really pulls back the curtain on the true power dynamic inside your HOA.
All right, here's how we're going to tackle this. First, we'll get into the patio dispute that started the whole thing. Then, we'll meet the homeowner who actually took on her own board. We're going to step right inside the hearing room to hear the arguments, decode the fine print that the entire case hinged on, and then, of course, reveal the judge's final decision. And most importantly, we'll wrap it all up by talking about what this means for you and your rights. Okay, so our story kicks off at the Scottsdale Trails community in Arizona. Now, like pretty much any HOA, they've got rules to keep the place looking nice and uniform. But a small change to just one of those rules lit the fuse for a full-blown legal fight. And it all came down to this one moment. In June of 2014, the board held a vote. And by the absolute slimmest of margins, we're talking just one vote, 4-3, they decided to change the rules about patios. It seemed like a tiny action, but it had some massive consequences.
Now here is where the story gets really juicy. The person who filed the formal complaint? It wasn't just some random resident. It was Sharon Oberritter, a woman who had served on that very same HOA board for 10 years. She was convinced her fellow board members had totally overstepped their authority.
And here it is, the core of her entire argument, taken right from her legal petition. She claimed the board's vote went directly against the community's foundational documents, the CC&Rs, which are kind of like an HOA's constitution.
So let's just boil this all down, right? Ms. Oberritter was basically arguing that the board couldn't just change a rule like this with a simple little vote. She believed this wasn't just some minor tweak, it was a fundamental change to the community's constitution, which, according to their own rules, needed a 2/3 vote from all the homeowners to pass. So, the case ends up in front of an administrative law judge. Both sides get to make their case, and two completely different stories about what the board did start to emerge.
First up, testifying for his wife, John Oberritter laid out their biggest worry. See, for them, this wasn't just about a couple of patio chairs. It was about protecting the whole look of the community and, let's be honest, their property values. They saw this rule change as the first step on a slippery slope towards a decline in neighborhood standards.
But the HOA board, they saw things completely differently. A board member, Michael Vuxen, testified that this was really no big deal. He argued it was, and I'm quoting here, a semantic change. In his view, they weren't creating some brand new rule, they were just clarifying the old one to make everything a little more consistent.
So who was right? Well, to figure that out, the judge had to do a really deep dive into the HOA's governing documents. And this is where the tiny details really matter. We're going to look at the exact same evidence the judge did.
Okay, so check this out. On the left, you have the original Constitution, the CC&Rs. It's super strict. Nothing but normal patio furniture, period. But then look at the 2012 rule. It added a huge exception, without prior written approval of the board. Then, the 2014 change just kind of rephrased that same idea, you see? This subtle difference in wording is, well, it's everything.
And this, right here, was the board's killer argument. They claimed that their 2014 vote wasn't an amendment to the super important CC&Rs. No, they argued, it was just a clarification of a separate document, the rules and regulations. They were just doing a little administrative housekeeping, making things line up. That was their whole defense.
So, the arguments were in. The documents were all laid out. And now, it all came down to how one person, the judge, was going to interpret it. What was the final call going to be? And the verdict was crystal clear. The judge dismissed Sharon Oberritter's petition. The HOA board won. That 4-3 vote was going to stand. But why? Well, the answer comes down to this key legal idea, preponderance of the evidence. This isn't like a criminal trial where you have to prove something beyond a reasonable doubt. Nope. Here you just have to convince the judge that your side of the story is more likely true than not. Think of it like a scale. You just need to tip it slightly in your favor, even if it's just by 51%. And that is exactly where Mrs. Oberritter's case fell apart. The judge basically said she didn't bring enough evidence to tip that scale. The official decision says there was no credible evidence presented to prove the board's vote was illegal.
She just couldn't convince the judge that her interpretation was the more likely one.
And from there, the process moved pretty fast. The hearing was on December 9th, the judge made his decision right before Christmas on the 23rd, and by March of the next year, the whole thing was certified as final. For this patio power struggle, the case was officially closed.
Okay, so a dispute in Scottsdale got settled. But what's the big picture here? Why should you care? Because this case perfectly explains a fundamental concept about how HOAs work that applies absolutely everywhere.
It really all comes down to knowing the difference between two key documents. On one side, you've got the CC&Rs. Think of this as your community's constitution. It's the big foundational stuff. Changing this almost always requires a massive vote by all the homeowners. But then, on the other side, you have the rules and regulations. Think of these as the day-to-day operational rules. And here's the kicker. Boards often have the power to clarify or even change these on their own. No homeowner vote needed.
So, here's the most important takeaway from all of this. When a board says they're changing the rules, the real question you have to ask is, which rules? Are they trying to amend the big deal constitution, or are they just tweaking a day-to-day regulation? The answer to that question changes everything.
And that leaves us with one last pretty important question for you to think about. In your own community, do you know where that line is drawn? Because understanding that difference is the real key to knowing where your board's power ends and where your power as a homeowner truly begins.